Thank you for joining us and for being a part of the festivities on this third and last day. My name is Mike Wassenaar. I'm the president and CEO of the Alliance for Community Media based in Washington, D.C. It's good to be here with you. And it's good to kick off Friday with three estimable attorneys, all of which I've had the pleasure to work with in one way, shape, or form. One of them actually was my attorney, Bernie, actually. We'll talk. I'll introduce him in a moment here. But what we want to do is, over the course of the next 75 minutes, talk about three areas of concern for everybody in the room. And I just want to note the sort of the tripartite nature of our discussion here with our three attorneys, three key issues. It's not meant to be a religious theme or anything like that, but folks think in threes. So just think about the three things here that we talk about today. Well, we'll be talking about the FCC, some federal cases that you should be interested in, and Congress over the course of the next 75 minutes. So we'll talk about these three areas, and then we'll have plenty of time for discussion at the end from the room. So,
Mike, in this analogy of three, am I the Holy Ghost or am I the ugly?
So, as a fan of Milton, I can say that, well, you've read Paradise Lost, right?
Yeah.
Okay. Anyway, well, we'll have the literary discussion a little bit later. All I can say is that, yeah. Anyway, so we'll have probably about a half hour of discussion from the floor here at the end of the 75 minutes. So take notes along the way with specific questions that come up from our panelists during the course of the discussion today. So let me take you from stage left to stage right, and this will be the order in which we begin our discussion. Joining me to my immediate left is Nancy Werner, who is the legal counsel with NATOA. NATOA is a key partner of ACM with a lot of the national and regional work that we do. And Nancy's been an invaluable resource for the organization over the course of the last year that she's been legal counsel. It's been about a year, right?
Yeah, actually, I think it'll be a year tomorrow.
Yeah. So let's hear it for Nancy Werner. And Nancy's going to talk about the Supreme Court case that NATOA partnered with ACM and the Alliance for Communications Democracy on that could conceivably affect everybody in the room. To Nancy's left is Mike Bradley, who has the distinction of being my attorney for about 12 years. Thank you, Mike.
Thank you.
Served me well. He's based in Minneapolis with a practice that works with local governments and PEG organizations around the country, Bradley Law. So Mike will talk with us a little bit about some FCC proceedings that are going on that affect everybody in the room. And the Natalie-attired Jerry Lederer joins us up in the cleanup position. I'll be moderator here, but Jerry will be leading us in a discussion of specific actions we can take over the course of the next 18 months as we have a new Congress and we also have some new faces at the FCC. So Jerry's specific discussion is going to be really about sort of action steps that your organizations as well as local government partners should be thinking about and doing, not just tomorrow, or later today even, because there's probably some things that you could be doing later today, but over the course of the next 18 months. So let's hear it for the Honorable Mr. Lederer.
Oh, sit down, it's all right.
And I'll be acting, maybe it's a little bit of my nature, I'll be acting as sort of the WWE referee amongst the three of them over the course of the next 75 minutes. But actually, we won't be having...
This is his dream. He's got three lawyers that he can tell to shut up.
Exactly.
I mean, come on. This is Mike's fantasy world. Hey, come on.
We're going to also provide you with a PowerPoint here, and I'm not sure if everybody in the room can see this or not. I'll distribute this as well for your notes later on. Each of our speakers is going to be talking about the three items that we'll outline on the PowerPoint, but they're not going to be reading off the PowerPoint. All right? So it's there for your reference. I'll be providing it for you here during the course of the discussion, but do not expect them to give you a verbatim read of the PowerPoint. That would just be total death. All right? So let's kind of kick things off here. And let's turn it to Nancy Werner. Nancy, I'd like you to talk a little bit about a case that some folks may have heard about that's being heard by the Supreme Court. The case is Manhattan Community Access Corporation versus Halleck, and it's coming up soon, actually.
It is. It is coming up soon.
Go ahead.
Yeah, thanks, Mike. So I have to say, first off, that I'm violating one of my hard and fast rules, which is to never go after this guy. He's got that perfect speaking voice, and every time I hear him speak, and then I hear myself, like, oh, man, so apologies. You'll have to train me.
Accept it.
All right, anyway, so let's get down to it. So I'll just call it the Halleck case. It has actually a lot of little issues in it, but I'm going to try to just stick with what I think is the most significant potential outcome of the case. So just for background, the issue in the case is an access center that is a privately run entity. Privately run meaning not a government entity that provides the access services in Manhattan. And they had an issue with a couple of individuals who were providing content to the station and I don't want to go into the whole factual background, but basically ended up suspending a couple of people from providing content for a certain period of time or perhaps indefinitely. And those individuals took the position that the Access Corporation is subject to the First Amendment as a state actor and cannot do what they did in terms of suspending them from production. So that's kind of where we come from. And the issue that's before the Supreme Court is really this question of whether or not the private access center is a government actor, is a state actor who has First Amendment obligations to these individuals.
And an important issue here, really, for most people's understanding, is that it's the First Amendment bars government.
Yes.
From banning speech.
Absolutely, yes. So thank you for clarifying that. So, I as an individual can muzzle Mike right now, and there's no First Amendment violation. But the government cannot. The government has restrictions on what they can do in terms of inhibiting one's speech. So that's why the question of whether or not this public access center is a government actor or a state actor is a big deal. If they're not, the First Amendment doesn't apply. If they are, then it does. So that's the issue that's really before the Supreme Court. The Second Circuit is the Federal Court of Appeals that heard this case, and they said that the Access Center that this is a public forum, they're a state actor, and so the First Amendment applies. That issue is going up to the Supreme Court. So in my view, that question is kind of an interesting question, and it will impact some PEG access centers that operate in a similar way. Although I have to say that the parties have, particularly Halleck, has framed the issue for the court pretty narrowly, and they've really framed it in the context of New York state law. To say New York law says that cable operators have to give PEG channels, and that a public access channel is open to the public on a first-come, first-served basis. So they have not reserved, the argument is that New York law has created a circumstance where public access channels are a public forum. So they've opened it up to the public like a public square, like the town square, where you've opened this up and said anyone can come here and speak with very little. Go ahead, Mike.
And to just be clear, what you're saying is that they're talking about this as a specific New York instance.
Yes.
And not every state has that.
Not every state has
dictate.
this, yes. And in fact, the Halleck brief before the Supreme Court says it's a very unique circumstance in New York. So they really are trying to narrow the application of this case. So if you just look at it there, you think, okay, maybe something could come out of this that's going to affect public access centers, and there might be some clarity on how the First Amendment applies. Okay, but why I'm here, and why this is a big deal that all of you should be aware of, is because of an amicus brief filed by NCTA, which is a cable lobbying organization. They filed a brief that said, in essence, we don't really care what you decide on this whole public forum state actor kind of thing. We take no position on that. What we want is for you, the Supreme Court, to say that the cable operators have First Amendment protections in their cable system. What they mean by that is they want to say that local government or states cannot require cable operators to designate channel capacity on their cable system for PEG. They want to say that their cable system is their property, and the government can't come in and require them to allow their property to be used for PEG channels. So that's obviously a much bigger deal than whether New York state law creates a state actor or creates a First Amendment obligation on the part of a private access center. So that's where Mike got involved and where NATOA got involved, is because this brief, again, it doesn't go to an issue that's before the court. The parties involved did not raise this question. It is a separate entity who's saying, even though Supreme Court, this is not at issue here, we really want you to consider this. And they're not really asking the court to rule on the First Amendment question. They're doing a little bit more of a sly backdoor approach of saying, we just want you to acknowledge our First Amendment rights and acknowledge that you're not interfering with them in however you rule on this case. That, in my view, I'm sure you agree, opens the door for the next case. That's really what they want to do, is get the foot in the door and be able to say, well, the Supreme Court has already ruled that we have First Amendment protections with respect to our cable system, and you can't, and that raises the issue of whether or not government can require PEG channels to be set aside at all. Does that make sense? That's kind of the issue that we're facing in this case.
And I think just so people get a sense of what could happen in a Supreme Court case, I think it's kind of important to note that the Supreme Court can do whatever it wants.
Yeah.
Right? This is sort of the precedent of how the Supreme Court works in its rulings. Like the Citizens United case wasn't about public finance reform across the United States. It was about a specific film. Yeah. Right? And that film basically blew up public finance restrictions across the United States. Right? So there's an open question about, with this court composition that's changed over the course of the last 20 years, how they'll proceed on some of these questions.
Yeah, exactly. And that was in response to this NCTA brief, as Mike mentioned, ACM, the Alliance for Communications Democracy, and NATOA filed a response, basically, an amicus brief with the Supreme Court saying, we're just responding to the NCTA argument. We're not getting involved in the substance of what Halleck and MNN are saying. We're just responding to the cable industry's lobbyist argument. And our very first argument was, you, Supreme Court, should not even consider this issue. It was not before the court below. The parties haven't raised it. It hasn't been briefed. There's no reason to even consider it. And there's also this just general principle that the court isn't going to address a constitutional question unless it has to. And so, that in this case, we're saying, not only is it not before the court, it's also an important constitutional question that you would normally avoid answering unless that was the only way to resolve the dispute between the parties. So there's a very good argument that the Supreme Court shouldn't take this up, but as Mike said, they can do whatever they want. And if there are justices who are interested in this question, and we think there are a few who are interested in this question and would be sympathetic to the cable industry's argument, they may push the rest of the court to address this question. So based on precedent, I would venture to say they shouldn't take this up, but it doesn't mean they won't. If the justices want to, they absolutely can opine on this issue.
And a more likely scenario could be they have a footnote or some other sort of response,
Yep.
a statement that comes as a result of the question, opening the door for, say, a specific cable operator to sue a local government.
Absolutely. I mean, as I said before, that's really, I think, what they're looking for. They're not looking for the court to say PEG channels are unconstitutional. They're looking for the court to have a footnote, something that gives them something that they can use for the next case. So, the best outcome for us is the Supreme Court ignores this entirely, doesn't touch it.
And to be fair, this is also an argument that like a Verizon and a Comcast uses quite often in disputes with local governments. Actually, we've seen this in the Vermont proceeding that's happening right now, where Comcast tried to make the claim that basically their speech rights were being interfered with. I mean, so it's not an uncommon
No,
tactic
it's
that's been
not.
used.
But it is still an unanswered question. I want to be clear that the Supreme Court has not said, the Supreme Court says that cable operators have First Amendment protections. They have First Amendment rights in certain circumstances. There has not been a ruling on the requirement that PEG channel capacity be set aside from the cable system. And from the cases that NCTA cited in their brief, the cases that are out there, the PEG channel set aside to me seems very different because typically that will come through a cable franchise agreement. Typically it is part of the consideration that the amount that the cable operator pays to the community to use the local rights of way for their system. And that is different than, say, a newspaper. So the NCTA is trying to argue, you know, cable operators are just like newspapers. You can't interfere with our efforts to get our chosen content out to the world. But newspapers don't have permanent facilities going all over the rights of ways of the communities. So it is a different situation, and I think there is a very good argument for distinguishing the PEG channel set aside, even from, there's been cases on the must carry provision where the cable operators must carry broadcast channels. And even those were upheld, those requirements were upheld. But I think we're even in a different situation here because the whole rationale for having PEG channels in the Cable Act is different than the protection for broadcast channels. But also you have this fact that the PEG channels are provided in exchange for the benefit of using the rights of way that the cable operator doesn't otherwise have. So that's a way of saying, even if this issue is teed up, I wouldn't sit here and say the cable operators are going to win if they bring this up, you know, in the future. I think we have a very good argument that this is a different situation from newspapers, and it's a different situation from the must-carry requirements.
You know, and to just kind of put a fine point on this, there are other amicus that entered into the case too. They all seem to have their own agendas, though. I think. Too, it'd be another way to put this.
Yeah.
I mean, a lot of amicus said something like, we have nothing to say about this case, but it pertains to us because of our agenda,
Yes.
right? I mean, so there's a lot of that sort of...
There is, which I think actually is probably to our benefit, because if I'm the Supreme Court, which I'm clearly not, but I would look at this and say, oh, there's all these other competing interests that are very concerned about how we rule on this. We're going to keep this very, very narrow. We're going to rule only on New York state law. I mean, that to me would be the best outcome for everybody involved, and probably the easiest course for the Supreme Court to take, and hopefully they will do that, rather than, you know, there are other amici in the case who are concerned about, as you said, one of them was a police accountability organization that's worried that, you know, if private public access centers are not government actors, then privately run prisons wouldn't be government actors, and there wouldn't be constitutional protections for the prisoners. So, I mean, it gets getting all over the place in terms of where this issue could lead. And so hopefully what that means is the Supreme Court says, let's not open a can of worms here. Let's
Stay
be very...
stay in your lane.
Stay in our lane,
Yeah.
exactly.
And then from a... Yeah, go ahead.
I hear these discussions, and I really wonder how much of us are paying attention. Let me just ask this question, and if I have it wrong, you guys correct me. The worry about First Amendment limitations or running afoul of the First Amendment, could we say that that's the reason why an awful lot of communities created their ACM members to start with?
Yeah.
Because the idea being, you know, if you wanted to have any kind of control or editorial control or management of the channel, if the government did it, there's this expression under the color of law. If you contract that service out to the ACMs of the world, there's that distance, and that's one of the real fears here, is that that distance is not being reflected in this case. That somehow that distance is being wiped away, and they're saying it may as well just be New York City.
Yeah, and to be the roots of this case, I mean, we could go through a sort of a clinical forensic history of how the whole thing unfolded, how this car accident occurred, right? Because it kind of feels like a car accident that we've been trying
I just want to make sure everybody here understood kind of what's at stake. I mean, the whole idea of the independence and the role that a PEG center plays for their local government in exchange. I mean, sometimes people may look and say, gee, well, what is it that we're giving the government back?
I mean, and this is sort of an interesting sort of family fight that to my perspective, because one of these organizations is an ACM member, another one is a longtime ACM supporter, right? So I mean, this is like fights within my family. Now, there's a certain part of MNN's argument that says we're a nonprofit, we're not the state, right? And in the original Halleck filing, the claim was, oh, they also sued the city of New York.
They did.
For MNN's actions, and the court basically kicked that part of the case out because basically it seemed like Halleck and Menendez were trying to sue everybody, bring everybody in to be held responsible, and to be fair, I think they went to federal court, not to the New York PSC, which is theoretically what they should have done if they had a complaint against MNN. Because they did want to make a federal case in the matter. They did want to federalize public access channels. They did want to make a claim that all public access channels are state forum. So that's part of the. So that's the other side of the coin on this. And I'm sympathetic to a number of our organizations that have read this case and want to support MNN up to the water's edge, if you will.
The water's cold.
Yeah, right. I mean, to say, I've had some kind of conversation with a large access center, and many of us were set up by government action, but we're independent in that we're not controlled by local government. But you've got this sort of key relationship with local government, which continues.
We had this really good lawyer up in Minnesota that took care of all this for you.
That's a different panel for a different day, Mike. There's. And at its best, this case should have been mediated and never gone to court, I think, because of the very dangers that Nancy points out. So mark February 25th on your calendar. That's when the oral arguments occur. We'll probably have some updates for everybody, probably some tweeting happening that morning, because I think a number of us are going to be down at the Supreme Court steps or in the courtroom itself. Which will be fascinating too, because I would not be surprised if Dee Dee Halleck doesn't bring a camera and try to violate court norms during the course of the case. But that's kind of who she is. So watch this space. This is, I think, an important case in a lot of different respects.
Say, Mike and Nancy,
go ahead and put that a little bit closer.
I don't understand with this case. Halleck was allowed to be on the public access channel, and got to speak his mind on whatever it is he wanted to, her mind on whatever it was she wanted to talk about. Isn't that enough?
Yeah, it's curious. That was never an argument that MNN brought up, because it turns out that the offending speech actually aired on the channel.
Right.
Once, and then
Once.
and then they barred it from being aired again.
Yeah,
I think I think what triggered it, Mike, was letters from the Access Center to the two plaintiffs saying, we're not going to air this anymore. I think Dee Dee was suspended for a few months.
3 months, and the other
the
producer was suspended for life.
Yeah, because for an alleged physical altercation, I think that was slightly different. So the facts are really messy, but it's true that the offending speech was shown on the channel,
right. And
yet here we are.
Yeah.
Because I'm thinking, if I'm an access organization, do I have to play somebody's programming over and over again?
Is New York,
Right?
in New York's law, setting it up as open in a first come, first served basis, at least the way this is being framed in this case, has limited the discretion. That's part of the issue here, is by opening it up the way that New York has opted to open it up. They have limited their ability to say once is enough. They haven't made that argument, but I think that's the underlying theory, is that you said first come, first serve, I'm here, here's my show, and they said we're not playing that again.
I mean, the other thing I would just say is that sometimes the case is not about the case. Yeah. This case, I think, was brought to try to air dirty laundry. and investigate MNN. And actually, that's been what specifically has been told to me as I've been trying to get the parties to back down and not go forward. It's like, oh, well, we can't drop the case because we want to get into the personnel records of all the MNN staff, and we're on a and it's like, oh my God, stop. So, you know, the unfortunate consequence here is that this could be basically like a match that's lit on a tinderbox that basically has the whole system go up in flames. So
Let me ask you this, Mike, are you able to look in the mirror without it being a conflict of interest? How do you have that conversation?
you know, it's
Never mind.
well, I mean,
We should move on.
Well, let's move on. There's a drink or two to be had in that discussion. So, thank you, Nancy. I really appreciate your analysis on this.
Thanks, Mike, for your leadership on this
Yeah.
issue. This is
Yeah.
this is a big issue, and ACM has really taken the lead. We appreciate it.
Yeah, and it's been great having NATOA on board with this thing too, because it does affect a lot of NATOA members as well. So let's turn to the FCC a little bit. I think it's interesting talking to the trade press. They're surprised by the further notice of proposed rulemaking on cable franchising being as active as it has been. And I actually talked to a reporter 2 weeks ago. They said, "What's up with this? It's like all these filings, all these communities across the country, all these religious organizations, all these local businesses, all these individual producers." Boy Scout groups. I mean, it's been an outpouring on this. Why is this so important, right? I mean, so I think this caught the trade press a little flat-footed, and it's not clear to me that the FCC expected the outpouring that's occurred on this case. Can you talk a little bit about the importance of the rulemaking and why it's been so resonant with like your clients and people you've talked to around the country?
Well, I can. And good morning.
Here's a softball.
I'm so glad you asked. Let me talk about it. I just want to thank, first of all, Mike for inviting me, and Sue for inviting me. I had no idea that it would be so cold in Minnesota when I accepted to come here, and so pleased that when I left, I could leave all that cold behind.
Really? It's not exactly warm here.
It is for me.
So,
it's 80 degrees warmer here, let me tell you.
I should say, though, there is no curling club in Long Beach.
Not yet, right? It's the fastest growing sport in America.
If you want to talk about
If
the
you
rules
haven't tried it, you should.
Yeah, Mike is a part of a regular team at the St. Paul Curling Club, which is a great national institution. He can tell you all about the rules of curling.
It is. Thank you. Yeah. Yes, the U.S. curling team won the gold medal. All of them, except for one, from Minnesota. The other one was from Wisconsin. And you should all try it. But it was so cold in Minnesota, they canceled curling Wednesday night. So I didn't miss curling, so that's good.
Okay. All right.
Let's get to business. What Mike's talking about is the FNPRM relating to cable franchising at the FCC. And really, in my view, it's probably one of the most serious and important dockets that I've been involved in and that my clients have been involved in. And I was very appreciative that so many folks saw the urgency to participate in this proceeding. And part of my message today, and I think Jerry's and Mike's and Nancy's as well, is we need to continue to engage on this issue. Even though the comments are in, reply comments are in, there are still things that you can do, and we'll talk about those things. And I also want to mention just the efforts that ACM and its members played in this matter. The ACM membership was unbelievable, let me tell you. We, as we were preparing our comments, we were looking for support from, to show, what the impact of this proceeding was going to be. And ACM members made videos, they submitted short comments, they talked to Congress, members of Congress, they worked with the local press, and there were newspaper articles published. You know, all of that, all of those things that the ACM membership did made it into our comments, I can tell you that. It made it into Jerry's comments, I can tell you that. It made it into Nancy's comments, and of course the Alliance's comments. And all of that then becomes the record that's going to be before a court if the FCC ever decides to take action on, final action on this matter. We hope that it doesn't. And I think that you'll find, and hopefully after today you might be more convinced that what the FCC is proposing to do is absolutely wrong. Absolutely wrong. But let's talk about what it is that the FCC is doing, in case those of you in the room that are unfamiliar with this matter. The FCC is proposing to make a rule that would change the way franchise fees are calculated. Essentially, it would allow cable operators to offset all of the negotiated in-kind consideration that is in cable franchises, okay? So what does in-kind mean? That's a little bit of a nebulous term, right? It means, to me, it means essentially everything except the franchise fee, right? The 5% gross revenue fee. So what does that include? It includes institutional networks. It includes transmission lines from a city hall to your master control center. It includes your PEG channels. It includes electronic programming guide, video on demand, maybe even customer service locations that are required in a franchise. All of these different things, and there's more, right? There's free cable service that could be included in that as well. And so you take, that's what they're proposing to do. So what then is the impact, like Mike asked? And I'll tell you, it alters decades, literally decades of past practices between cable operators and local jurisdictions on how a franchise fee is actually calculated. We have 35 years now where the franchise fee has been calculated on a percentage of the gross revenues. Why? Because, in my view, the Cable Act is very clear on what a franchise fee actually is. But it will also significantly reduce, if the proposed rulemaking went into effect, public benefits such as access television, institutional networks, complementary cable service, all those types of things. There's no doubt that those things would be reduced. The financial impact is difficult to precisely name, right? But the estimate has been, it's going to be a reduction of franchise fees of 20 to 30%. That's a huge impact on local franchising authorities, and that funding is used, of course, to fund access channels and access organizations. That'll be a tremendous impact. Some maybe hidden impacts would be the retroactive application of such a rule. If you can imagine. And
so, I mean, this is something that's a little hair curling when you talk about this. Conceivably, there could be a look back under the rulemaking, and for how long?
1984.
Right. How long? Well, you don't know how long, but for sure it could be. The law, remember, hasn't changed. The law has not changed. So if the law hasn't changed, but the FCC is interpreting it in a way to say, well, this is what the law means, well, why can't a cable operator go back at least through the statute of limitations period, right, which may be up to 6 years? Maybe it goes back to 1984.
Or 92, I guess, was the last time they took.
Yeah, right. So
your estimate of 20 to 30%, that's seems fairly conservative, right, Mike? I mean, that's not a scare tactic, right? Because
no, it's not.
Tom Robinson, who's a brilliant needs assessment type of person that we work with. I mean, Tom did a NATOA program where he said that the estimates could be up in the 60 to 70% area, but he was quick to add, that would be in communities where there were multiple providers, right? Because if you have to pay for a PEG channel and you've got 2 or 3 cable operators, that means you're paying triple for that same PEG channel. So, yeah, no, let me shut up.
Well, no,
Mike is trying to scare the hell out of you. If he doesn't, I will.
But I'm really not trying to scare the hell out of you. I'm really trying, eventually, I'll get around to it, is to show you that they're absolutely wrong on what they're doing. But if the rule goes into effect, it does have a tremendous impact. When you go to the, the price impact, in our comments, we looked at the value of an access channel, which there really isn't any clear way of determining what the value of a public access or government access channel is. But we used least access channels as an example. And if you took the formula for least access channels and kind of applied it to PEG channels, the impact is tremendous. So and we use the example of a large metropolitan city, and the impact was a 50% reduction in franchise fees for that particular jurisdiction. There was another one that we used, I think in New York City, and it was less than that. It was probably in that 20 to 30% range. So, and that's just one piece.
Right. That's one aspect. But you can imagine, in the Twin Cities, there are a number of communities that have 5 or 6 channels, right? And so that there's a multiplier effect for each.
Right, and that's what was happening in that metropolitan city that I was mentioning. There was multiple channels. I think there was 9 channels, and so it was a big impact. Another kind of unknown or not super clear impact is that this type of ruling will allow cable operators to double recover its costs. And what I mean by that is the Cable Act allows cable operators to recover their franchising costs, which includes these in-kind considerations. So the cable operators have already recovered these costs. Not only have they recovered these costs, they got 11.25% interest on top of it. So now you have a situation where the cable operator, in most instances, has probably already fully recovered these franchising costs. And now, according to this FNPRM, the FCC will allow cable operators to not only recover their costs, but to recover the fair market value of these assets. That's a big difference between cost, right? Because if you have an institutional network and the cable operator values every site at $1,600 a site a month, that's a big number, right? If for any size jurisdiction, it's a big number, right? That's a lot different than recovering the actual costs of building a fiber line from point A to point B.
That they probably already collected
That
from
they already
subscribers.
recovered, okay? So that's the impact, and it's terrible. But now let's go over why the FCC is wrong, okay? So you have to go back and look at the definition of franchise fee, which has not changed. It has not changed since it was adopted in 1984. So a franchise fee is any tax, fee, or assessment that's imposed on a cable operator, okay? And just remember that, tax, fee, or assessment. When we're looking at in-kind consideration, it's pretty clear it's not a tax. It's pretty clear it's not a fee. So the only thing it could possibly be would be an assessment. Is it an assessment? And we'll go over that. It's also important to know what the nature of a franchise fee, or what a franchise is, right? Franchises are essentially contracts. They're kind of a weird type of contract because they're ordinances and contracts at times. But it's a contract. How are those contracts put together? The Cable Act tells us how these contracts are put together, these franchises are put together, in most instances. They're put together by negotiating with the cable operator, informally. That's one way. The second way is through the formal franchising process. The formal franchising process ultimately results in the cable operator submitting a proposal. A proposal. And then the city, the local franchising authority, then either accepts the proposal or doesn't accept the proposal. Nowhere in that process is there a situation where a city makes demands. Nowhere in that process does a city exact anything from the cable operator.
There's no gun to the head.
No, these are proposals, these are negotiations, and they are proposals that result in a contract. And they benefit both sides, by the way, right? Because while there are some considerations given to the city, there's also other considerations that are given to the cable operator as well. So what we did and others did in the comments were to show that if we look at the clear language of the Cable Act, so remember, tax, fee, or assessment, right? So just look at the plain language. Just look at the plain language of the Cable Act. Cable Act, so to be an assessment, the assessment is defined as an imposition of something, such as a tax or fine, okay? So is in-kind consideration an imposition of a tax or a fine? I don't think so. Then look at the word imposed. Look at the word imposed. Just the plain dictionary definition of the word imposed. The examples they use are impose a tax, impose new restrictions, impose a penalty. So when you look at just the plain language of the statute, it's clear that there isn't anything that relating to in-kind considerations that would be either an assessment or an imposition or imposed. Now, the FCC and there was a handful of comments by the industry, and they don't refer to the in-kind consideration as in-kind consideration or in-kind provisions. They refer to it as in-kind exactions. In-kind exactions. And the reason they do that is because there was a statement. Mike mentioned that sometimes courts make statements. There was a statement in the Montgomery County case, Montgomery County versus FCC. And in that case, the court said that, well, it could be possible that in-kind exactions could be an assessment. And then they referred to a U.S. Supreme Court case called U.S. versus Austin or something like that. And in that case, there was an exaction by the government against somebody. It was a civil forfeiture proceeding. So an in-kind exaction, according to the Montgomery case, is a situation where the government takes away property like a penalty. Okay? That's what Montgomery County stands for, if that's even a holding. I don't think it is. I think it's just dicta, which means it's not binding on any particular body.
You know, and I hate to sound like Bill Clinton here, but the problem with the FCC's position is that they seem to confuse can and is, right? I mean, just because something could be doesn't mean that it is something.
Right. Yeah. It could possibly include in-kind exactions. Well, these aren't exactions. That's my point.
Right.
So there's no circumstance in which these in-kind provisions could be seen as exactions, and therefore they cannot be an assessment at all. Is everybody with me?
Yep.
Okay.
So what happens next? I want to gently glide to our cleanup here in a moment. But what happens next in this case, Mike?
Well, like I said, the comments are in, reply comments are in, but that doesn't mean we're at the end of the line by a long shot. You should still engage your local officials, I think first. Engage your local officials. Let them know what's going on with this proceeding and the impact that it will have on the city and on your organization. It's tremendously important that they know, because the people that your local officials interact with may have some sort of influence on the ultimate outcome of this. Engage your congressional delegation. Let them know that you submitted comments, or if you didn't submit comments, let them know the importance of this proceeding.
But they all did. ACM and NATOA submitted comments, so if you didn't do your own, you share NATOA or ACM's, and Michael will let you share his, and I'll let you share mine.
Yes,
You got
absolutely.
plenty of things that you can send to your member.
Yes. And then engage with the FCC. There's still opportunities to submit ex parte letters. And I'm sure the FCC may be looking for ex parte letters. Maybe not from local governments, but they may be looking. And then finally, continue to participate with ACM and NATOA and other organizations.
Yeah, and just so you know, there's going to be an opportunity in March if folks want to come out to Washington, D.C. The National ACM Board will be in D.C. the second week of March, and we're actually going to be doing some Hill visits and coordinating some FCC meetings during the course of that week. So if you want to join us there, I'd welcome any member to come out, and I can give you details about that directly, all right?
And if you can't do that, between now and the next 3 weeks, talk to your city and/or county electeds, because they're all coming to DC at the end of February and early March for the National Association of Counties and the National League of Cities, right? And if, let me be the unpolite one here. You either educate your electeds on this threat this year, or you argue with your electeds for general funds to support your operations next year. It's that simple. You know, this is an existential threat to everyone in this room. It is. It's not that local government doesn't want to fund you. They're not going to have the money. It's just that simple.
And I'll just add to that, if there's the money, but then
How
there's
can you
also.
add existential threat?
Sorry, it is. I'll emphasize why it's an existential threat by saying there is the lack of funding, but what I'm also concerned about is when the government is negotiating the cable franchise and the PEG channel capacity has been valued at a certain amount, they may cut back on the number of channels they're
Yeah.
even going to put into a franchise. So if you're sitting there thinking, well, we do fundraisers, we have other sources of revenue, we're going to make it, we're not funded through general fund dollars, we're going to make it. I am not comfortable with the idea that a local government facing the loss of their franchise fees, which typically either goes to PEG or goes to general fund or both.
Correct.
They could very easily just say, why are we doing these PEG channels? I want to use this money for the fire department.
I mean, that's my analysis for the threat across the country in both local franchising states and state franchising states, is that, this basically opens the door for the choice to be made. And I think, frankly, when times are tough, people take the cash.
Yeah,
right?
exactly. And
Yeah.
I'm glad you mentioned, state franchising. This proposed rule would apply in state franchising states. So that's the other thing. If you're sitting out there thinking, well, I'm protected under DIVCA or whatever you have there, I guess that's a different one. All right, I got it.
That's right.
If you think you're protected, you're not protected. The FCC is proposing, they haven't decided this, but they're proposing that this new interpretation of the law would apply even where there's a state law that addresses cable franchising and PEG.
Yeah, so if you got a 5+2 under DIFCA, and they say that the 5% is a hard cap, and unless you can justify that too as being a PEG capital contribution, you got a challenge.
So on that happy note, let's turn to what some action items that folks can be thinking about, particularly as we look at new faces at the FCC and new faces in Congress, because I think that does present some opportunities for our field and for our partners here in the early parts of 2019. Jerry, can you talk a little bit about what we're seeing and where the opportunity lies?
Absolutely, but if I could first, I'd like to thank Sue for the invitation, and it's an honor to be up here with Mike Squared and Nancy.
We're the Minnesota Twins.
That's it. There you are. Very good. I have learned over the years that I get intimidated by really smart people, and so I try to hide that with humor. So if I've interrupted other folks, you understand why, because they're really smart. One of these things is not like the other, right? We're about to hear it. I mean, for instance, the difference between Mike and I and Nancy and I is that they refer to this cable item as the FNPRM. To me, it's the effing PRM, you know? I mean, and if you don't have that attitude, you're in big trouble. Let me see if I can just sort of put an overall theme, and then we can talk about maybe how we can respond. The basic concept, whether it be cable franchising or the use of our rights of way for new wireless services, the basic concept is that we, the community, own the rights of way. And if you want to use our property, then you ought to pay us for using that property. And you ought to pay us what the Constitution says is fair or just compensation. Okay? Fair and just compensation is not the recovery of costs. If you want to understand just how ugly things are at the FCC, you can juxtapose the small cell order and the FNPRM order. And here's the deal. In small cell, when private enterprise wants to use local government assets, they have to pay the recovery of a reasonable cost. In the FNPRM, when local government wants to use a government asset, we have to pay market value. Okay, there it is, folks. In that specific example, you know everything it is that you want to know about. The other thing is the reason that these things are related. I remember years ago somebody saying to me, God, you must be so smart. How do you keep all this in mind? And how do you understand these relationships between cable and telephone and the regulators? And I said, it's simple. And I'll explain it to you how simple it is. How many people here are parents, right? If you have more than one child, right? If you have more than one kid, you know exactly how this works. When your eldest comes in and says, you like the younger one better, she gets to stay up later than I ever did, she gets more of an allowance than I ever did, and then the little one marches in and says, yeah, but big brother gets this, this, and this. It's the exact same thing, right? We had this small cell order that went out and said that we're going to grant telephone companies access to your rights of way, and we're going to grant access at a severely discounted rate, and we're going to do it on an expedited basis. Oh, and by the way, we might allow you to put some sort of an aesthetic standard in, but you have to justify it from a cost standpoint. That's what it says. And the cable companies came in and said, oh, could you do that for the small strand things that we want to deploy? And the commission said, no, we're going to define small cell as something that's on a pole, right? So then the cable companies, they're all upset. They got nothing out of this deal. And almost miraculously, the next day, a proposal comes out that says, oh, and we're going to do this FNPRM, where we're going to say that they can offset all these things because it's a huge capital advantage to them. So what is it that we need to do? One, we need to recognize the threat, and we need to make sure that our local government officials recognize the threat. Here's a real simple way to explain it. Next year, if these two orders go through, the loss to local government will be greater than the loss of the Community Development Block Grant. The CDBG is the biggest pot of money that your local government gets, whether it's a city or county, from the federal government. It's just over $3 billion. $3 billion a year, and it's distributed on formula. What we're talking about is we're talking about numbers that are probably pushing $4 billion next year and will only increase on time, right? I think the capital loss is going to be right up front. The small cell loss is the one that's going to grow on a regular basis. So if you go in to see your local elected officials and say, hey, the FCC is proposing two ideas that, if left unchallenged, will cost us more than we get in CDBG, I think you have their attention. Okay? And once you have their attention, what you need to do is exactly what Mike indicated, and that is we need them to communicate with members of Congress about this threat. What do we want them to do? On the small cell side, we want them to co-sponsor HR 530. That's an eraser piece of legislation. That's a piece of legislation that says these small cell orders, they're null and void. We go back as if it's the day before. So it erases these two orders, and that's been introduced by Mrs. Eshu. Mrs. Eshu is a senior representative, Democratic representative from the Bay Area. And then you want to say to them, and would you please communicate to the FCC that you don't like this idea that they're floating on the FNPRM.
So we're saying, when you're saying you, we're asking a member of the House or a member of the Senate to express their disapproval
Correct.
to the FCC,
Yeah,
that they write a letter or they have a communication that's public to the FCC that says this is wrong, this has a negative impact, this has to stop.
It's amazing. I've never been to the UN, but Mike translates for me like my Philadelphia's to English. Thank you very much.
Hey.
He said, no. No, that's exactly, well, I'm saying exactly what Mike's saying, but I'm also saying that if your elected official wants to get in this game, they can be communicating to the FCC as well. Because as Mike said, the fact that the reply comments are in does not mean that the record is closed, right? The record's open for as long as, until they issue a decision, right? So you can say to your local government, and there's been a great turnout, don't get me wrong.
Right.
Mike's absolutely right. We've never seen turnout like this, and look, I think it's attributable because we haven't had leadership like we've had with Mike and Nancy in the two organizations for a long time. And the other nice thing is that Mike Bradley and I and all of our colleague competitors understand we don't win this, our practice is gone. I don't think we've ever worked harder together. So everything's moving in the right direction. Let's just keep moving it. So it's a twin threat. It's a twin threat, and the threat rises out of the same issue, and that is what is the value of our rights of way and how do we recover fair market value? Mike took you through the details in cable, right? There was never a constitutional challenge to the '84 Cable Act over the compensation provided, because a lot of people thought that Congress got pretty close to figuring out what fair market value was, right? They gave us the 5%, plus they provided for the ability to meet community needs and interests. Mm-hmm. If community needs and interests are now offset against the 5%, that deal's off. That deal's off. It's no longer clear that we're getting just compensation for the use of our rights of way, and we'll go there, but why should we have to? If we can kill this thing at the FCC, and we can, by the way, there's no rule that says that they have to issue anything. They have no requirement to issue anything. So human nature being like it is, if we can make it uncomfortable enough for them, let's do so. And elections do have consequences. If we had this talk a year ago, I'd have said a lot of the same stuff, but I wouldn't have believed it, right? Because we had nobody to exercise leverage. We now do. We now do, and we'll pursue it. So look, I know that really the most important thing here is questions and answers. So I'm going to shut up, and we can get into questions and answers.
I want to get that just one moment. I want to see a show of hands, though, from the group, and then get some Q&A here in the last 15 minutes. 12 U.S. senators have expressed disapproval to Ajit Pai and the FCC. 9 representatives have. And so far. And I think my invitation here to the group is that anybody who has not had that communication with their members of the House and asking their local representatives to talk with members of the House, please do so. And maybe we could just have a show of hands here. Who's participated in the FNPRM? All right. How many of you have made a communication to a House member? All right. So it's great. There are actually some key House members that are on that House Energy and Commerce Committee here in California. I think Anna Eshu is one. And then certainly
well, actually, we got
Doris Matsui is another.
Right. There was an announcement made last night that I guess the Democrats have gotten a little smarter over the years. They looked at their committee chairman and oh man, we have a significant number of elderly white gentlemen that are the chairs. And so they've created these wonderful things now called vice chairs. And so we have 2 vice chairs that are important to us, and they're all important, but 2 especially important to us. Okay, at the full committee, Yvette Clark of New York City, a huge champion of PEG, is now the vice chair of the full committee. We got lucky again. At the subcommittee level, Mrs. Matsui is now the vice chair of the telecom subcommittee. Again, another terrific champion for PEG. Mrs. Eshu has been a champion for us and is now sort of in a senior statesman status because she's been a ranking member and had to move on. So, yeah. Now, so good stuff for California, right? But you're 0 for 2 on the senators. Neither one of your senators got on the letter, right? Senator Markey busted his chops, got it, put it together. We went 0 for 2 with Californians. I guess if you're putting together your presidential campaign, I don't know. But we went 0 for 2. So, although I will tell you that, this was what Mike was alluding to earlier when we were sharing a laugh. There's an issue right now as to whether or not the FCC encouraged the telephone folks to file appeals of the small cell order as a means to keep us out of the Ninth Circuit. Right? We wanted to be in the Ninth Circuit because all the rules that the commission was overturning were here in the Ninth Circuit. I'm sorry, I say Ninth Circuit like everybody knows. The Ninth Circuit is California, Oregon, Washington, Arizona, Alaska, and Hawaii, but it's mostly California. So we really wanted to be here. And all of a sudden, within the 10 days after the order, what's called the lottery time period, all of a sudden, Puerto Rico Telephone, which hasn't been heard from in a millennium, shows up and they appeal. And Verizon appeals, and Sprint appeals, and AT&T appeals. Oh, and what's really interesting is they appeal in 4 of the circuits that are deaf to us. Are circuits that are not predisposed to like what we're doing and like what the FCC did. And there's and so we get called up to the Hill about a week ago, and we're asked about it. And sure, I've heard the rumor, but I can't document it. Interestingly enough, a couple of companies that were asked to file an appeal and didn't, then worried that they were going to have retribution against them by the FCC. So interesting, the companies that are getting the deal from the commission ran to the Hill.
So now the House is actually the House chairmanship is looking to investigate the matter.
And Senator Feinstein sent a note last night to the commission saying the same thing. Feinstein Blumenthal, Senator Blumenthal from Connecticut, again another mainstay of ACM, sent that. I was telling these guys this morning, I got a phone call from a friend to tell me that they understood that the FCC is reaching out to small cable companies, asking them to file comments in support of this FNPRM, because the only people that filed in this proceeding are NCTA and the Small Cable Association. Escapes me, Mike.
American Cable.
ACA, right? Verizon did a little bit, and that's it. And so, if you weren't angry to start with, maybe that'll get your blood boiling too. That this item is closed, and they're encouraging them. So we got to work just that much harder.
So let's get some questions here. Chris, why don't you go ahead? I'll get to you, Mike, and then we'll try to get to as many here before we end.
Started talking a little bit about this, but not quite. But is it the comment process the FCC uses somehow compromised, broken, or otherwise corrupted?
It's a great question, and it doesn't mean a damn thing to us right now. If we spend 1 minute worrying about whether or not the system is broken, then that's 1 minute we're not going to spend advocating. We'll let the people that can fix it, fix it. If we don't know that we're in a fight.
Same people that we're trying to.
Well, okay, but when we look at the record, I'll just push back a little bit on this. Roger Stone's organization has not been involved with our issues. All right. So just we haven't seen anything yet. like there was in the net neutrality case, where you've got some Macedonian group that's working on behalf of Vladimir Putin to make sure that we don't have free speech in America. That's not happened yet. I'll let you know in my newsletter if it happens, all right? So don't worry about it.
But in
No,
the
Mike,
meantime,
this is serious. It's no time for humor, okay?
I mean, it's not humor. I mean, it's grim. It's grim because it's real. I mean, so anyway, but I would not, to put a different point on Jerry's point, I wouldn't worry about that materially right now.
And certainly don't let that preclude you from filing ex parte comments you may file.
Correct.
Because right now, that is the system we have. That's the record that will be reviewed if the FCC proceeds, and then we're in litigation.
I mean, we have not seen dead people. We have not seen stolen identities. And we have not seen Donald
Again,
Duck file
humor.
yet. Yeah.
This is serious time. This is time for serious people. And my name is, and I'm running for president. What's the movie?
Yeah, exactly. Go ahead, Mike.
First, a quick comment and then a question. I was looking at the numbers. So we have 9 Congress people out of 435.
We've got some work to do.
We got some work to do. So
Right.
I just want to rally the troops here and say they're right. I mean, they're not telling us.
To be fair, though, I want to.
434.
I
Is that what
want
you're
to.
saying?
I want to. We've got
We've got one unseated. There's really 434, but
Yeah, one unseated, and one of those Congress members resigned. One of those Congress members resigned, so there's really 8 active out of 434. You can work the ratio, Nancy, because she's
It's
good
looking
at math.
better. It's looking better all the time.
However, I would say that 50% of the Hawaiian delegation has supported us. So thank you, Hawaii. Yeah, for that. But we need to step up, and it's a very simple thing for folks to do. Go ahead.
And then the question is, can you just give us the quick Reader's Digest version? Walk us through of the next step. If the FCC votes in this particular rule, just give me the readers or the whole group, the Reader's Digest version of what's next, and how could this ultimately play out?
FCC rules, there could be a request for reconsideration. If that's not done, there could be an appeal, similar to the wireless order appeal. And
there might be requests for stay to say we're going to challenge this and we want you to not, you FCC, don't put this thing in effect and mess everything up while we litigate. We tried that in the small cell and the FCC said no.
Here's
We asked the court said no. So
Here's
the
the
order
answer.
would probably go into effect even while the litigation is going on, is what you should assume.
Here's the answer. And everybody, if you were around when the cable modem order was issued, will remember this. Here's the answer. The day after the order goes into effect, you're going to get a letter from the cable company. And it's going to say that we believe that the market value of the in-kind services we provided in the last year is X, and we're going to recover that by reducing your franchise fee by Y for the next 5 months to recoup, and then it'll be, Y prime thereafter, all right? Because here's the problem. The cable companies have our money. They've got to give us our money. Right? They've got to pay the rent. They're not going to pay the rent if they've got a legal leg to stand on. So you want to know what the next step is, Mike? The next step is you're going to get a letter, and that's only if they're courteous. Right. And if they're not courteous, you're going to get a franchise fee that's somewhere between, as Mike estimates, 30 to 50%, or if you've got a multiple, it's going to be 30% of what, and that's the next step.
And to be clear, that FMPRM provides no explanation. Right? There's no explanation for the rationale or the calculation that a cable company would come up with. And in some jurisdictions, there's a very good, strong relationship between government affairs and the locals. In other jurisdictions, there's no relationship at all. So I think it's going to depend a lot on the company and how they act in terms of how they then roll out abuse of this proceeding.
Yeah, so what Mike and Nancy were saying were exactly correct. I mean, they outlined what our response is going to be. I don't think our response counts.
We've just got a few moments left. I got a couple more hands coming up. Go ahead.
Regarding this stage of the FNPRN process, should we really be targeting our House representative, or do we really need to be zeroed in on the Energy and Commerce Committee? Because we have 7 members in it, 5 in addition to the 2 you've mentioned, Eshu and Matsui. So, yeah.
And McNerney's on it, and then
Are these the ones we should be focused? I mean, I just wonder, where should we really be laser focused right now?
Yeah, I mean, I think if you're looking at a target, you look for, but I don't want that to be an excuse for anyone not to talk to the representative. I mean, I think that's, so yes, the subcommittee and the full committee is important and needs to be targeted. So that's like, but that means if you've got a strong relationship with, or any kind of relationship with the members of the House, I would not say no to that contact. So don't mistake that. You know, I mean, I hate to say this, but it's yes to both. We have to prioritize all the communications with the House, right?
Let me give you a refined yes to both. Let the national organizations worry about the committees of initial jurisdiction, and they'll reach out and make sure that people are doing that. Let everybody else reach out to their members of Congress. Remember, everybody's got 3 people in their delegation.
Because that's also where your power lies. I mean, you're talking to Jerry McInerney is not going to make a diddly-poo worth of difference, Randy, because you're not in his district, right? So we have to be thinking about our power. Correct. So we have to be thinking about our power, and our power resides in our communication that happens at the local level up, right?
Three most important words in politics. 3 most important ones. And if your letters and communication aren't starting with these 3 letters, then you're dropping the ball. As a constituent, if that's not how you're introducing yourself in every one of these communications, then you're leaving money on the table.
Okay. But Brian, and then we're a little over time, and I want to get you to your next session.
Yeah, but we're worth it.
Yeah, Jerry's worth it. Go ahead.
Do we expect the FCC to
Don't know.
Never.
Could be never.
Never.
It could be never. There are plenty of Wheeler Commission rulemakings that basically got deep sixed by the Pye Commission. So who knows? There's no time frame. There's no shot clock. Huh, imagine that.
Yeah.
And then a quick question here too.
Well, we had an incident with Clear Lake and Charter Cable. I don't know if you knew about that. They wanted to make it a 218 vote. They were trying to pass it through as a tax. Are you aware of that in California?
I think I am because of the
Can we
and
talk afterwards?
we don't have time to talk about that case, but I think I'm familiar with that case. I'm sorry we didn't talk about it here today. I want to thank
All the way over there.
Okay, real quick.
Is Jackie Spear one of those 8?
She's up. She already signed on.
She already signed on, good. And then I'm gonna go to my local elected officials, and they're gonna go, hey, this already happened to us because we're living under DIVCA. What am I?
No. The impacts will occur in California regardless of DIVCA. So
30 to 50% in California.
correct.
As a retroactive.
Correct. Conceivable. So DIVCA does not protect you, right? So just that would be the pushback I would give as your. Well, that's just because it's crappy now doesn't mean it can't be in the future. All right. So now. I want to thank the panelists here, especially the person who said he wasn't that smart who used algebra terms during the course of the discussion. Thank you so much, Jerry, Mike, and Nancy, for being a part of the discussion here today.
Thank you.
And thank you for acting. Please be sure to take action in the areas we're going to talk about. And if you need assistance in that communication to members of the House, I'm happy to help you, provide you with sample letters and the like. So please come see me afterwards. Let's go to our break, and I think the next sessions are at 10:30. Thank you so much, everybody.
Thank you.
At 10 what?
10:30.
You chasing us at 10:18?